My name is Steve Houck. I'm formerly Chief of the Antitrust Bureau in New York State. I want to thank the ABA for the great honor of being able to interview Kathleen Foote today. Kathleen is one of the leading figures in state antitrust enforcement. She is chief of one of the largest state antitrust bureaus in the country, the California State Antitrust Bureau. Kathleen, I have it on very good authority that you were a free-spirited child of the 60s. And here you are, you're running the California State Antitrust Enforcement Bureau, one of the most important enforcement agencies in the country. Your decisions affect major companies. How did you get from there to here?
Well, Steve, it was a very long and winding path. I'll be brief about it. My first interest in college turned out to be economics because of a class I took. It was one of those once-ever classes on Latin American economic development, or the reasons that it wasn't happening, taught by former Costa Rican President Jose Figueres, and that led me to spend a summer in Mexico studying similar kinds of things for several months. And that was really my first opportunity to see a country that was and an economy that was a paternalistic, highly regulated, closed system. It made quite an impression on me, and that really consolidated my interest in economics. Of course, I don't want to convey that I was that serious an 18-year-old. A lot of what I saw of Mexico, I saw from the back of a motorcycle being driven by a Mexican rock musician. But in any event, I came away with a strong interest in economics, which, of course, I ended up not really pursuing at that point. What I did do subsequently, after getting my BA and getting a few months of work at the Financial Post of Canada under my belt, was arrive in San Francisco with most of our generation, and decide I wanted to stay and start looking for a job. The only job I found that was not actually a secretarial job at the time, because by this time it was the beginning of 1970, was a paralegal job, which I got at the law firm of McCutcheon, Doyle, Brown and Anderson, now Bingham, as you know. And the attorney I worked for was Bill Schwarzer, who was an antitrust lawyer at the time, later became a federal judge in San Francisco, and did a number of antitrust, handled a lot of antitrust matters while he was there. I worked for him. A side point on that was that the associate working on the first case, anyway, that I worked for under Bill was now FTC Commissioner Tom Rush.
So antitrust team touched by the stars.
Well, I'm sure that we would all like to think so.
Oh, it's true.
In any event, it was a great case to work on. It involved a boycott. It involved the tourism industry in San Francisco, particularly the nightlife industry, which was extremely colorful at the time,
absolutely.
And populated by all kinds of very colorful people,
Yes.
whose depositions I summarized day in and day out. Went to trial. I watched the trial. And during that period, I was coming to terms with the fact that I was very likely to be working for most of my adult life, and if I was going to do that, then I jolly well wanted a job that was interesting, reasonably well paid, and high status. So I decided it was time to go to law school. When I got out of law school, I went back to McCutcheon as an associate, and did practice a certain amount of antitrust law there. However, during a period between then, the time I left that and the time I actually started working for the state, and being an antitrust practitioner on a full-time basis, there elapsed about 10 years, during which time I both had my kids and became very interested in environmental and land use law. I was on the city council of my small town and mayor for a couple of years, and pursued and I also taught at USF Law School, where I was the academic dean, and I taught in the land use and environmental area. When I was ready to kind of get back into the fray as a litigator, and I went to the AG's office, I was interested in the land section, which was doing some interesting things there, but they didn't have any opening in lands or environment or anything close. And there was an opening in the then quite small antitrust unit, and they were interested in hiring me, and their first question was, if you come to work for us, would you rather litigate against the oil companies or the insurance industry? And I thought, oh, I'm going to like this.
Hard to pick between the two evils.
That's right.
Are you a native Californian, by the way?
No, I'm not.
I know you went to college in Radcliffe in Cambridge, Massachusetts, right?
That's right, yeah.
And then you came out to California, and you were mayor of Mill Valley, California?
I was.
And did you learn anything as mayor that you were able to use in your later career as an antitrust attorney?
I actually think I may have learned more as mayor of Mill Valley than I learned in law school to prepare me for what
Why
came.
am I not shocked? What did you learn?
Well, hard to summarize, but I certainly learned a lot about group decision making, or as we used to say, because there are 5 city council members, how to get the 3 votes to make something actually happen. In multi-state cases, it's often how to get the 10 votes or the 15 votes or however many that you need. How to negotiate and compromise. I learned a lot about how cities work, the policy side and the essentially running the corporation side. All extremely useful.
So what year did you join the California State AG's office?
1988.
1988. And how many lawyers were in the office at the time?
Well, in the antitrust unit, there were only, I think, 4 in San Francisco, 2 in Sacramento, and I think maybe 3 in Los Angeles.
So 9 altogether?
Something like that.
And how many are there today?
We have 15 now, including myself. We've been as high as 16. I think that's the maximum, but that's large for state antitrust.
Right. I know most states, like New York, all the attorneys are in one office, and in California they're more scattered around. Is it difficult to manage people in different offices? How do you do that?
It is. We no longer have the Sacramento wing. After my boss Tom Green left, he was the last one there. So it's just San Francisco and L.A. And there's always been a supervising deputy in L.A. Who reports to me, but really handles most of the day-to-day things there. In terms of working together, once upon a time, we had more of a travel budget than we do now, and people could go back and forth more easily than we've been able to. We sometimes hook up by video conference to have section meetings. I go down to LA from time to time. But it does happen that someone can come start working for us and find that a year can elapse before they actually meet the folks in the other wing of the office.
So let's talk a little bit about the first case you worked on, which was the insurance case. That's the Hartford insurance case, which actually turned out to be a famous case because it got all the way to the Supreme Court, which is not the usual thing for most antitrust cases. So could you tell us a little bit about what the issues were in the case?
Well, the issues, actually the issues proved to be quite interesting to me because they involved municipal commercial general liability insurance, which had dried up for municipalities in 1985-86. In fact, at precisely the time I was mayor of Mill Valley. And Mill Valley was no different from others in suddenly having the insurance dry up and trying to decide what the alternatives were. I certainly had known nothing at that time about what may have led to the disappearance of the insurance. The case had been investigated for a couple of years by California, New York, and several other states. And about 3 weeks after I got to the AG's office, the case was filed.
Was it filed in California?
It was filed in California. There were 8 states. Later, there were another 10 states that joined. And I think ultimately there may have been a total of 20.
So that must have been one of the earliest multi-state cases, is that right?
It was. There had been MDL 150 before that, but that
was the oil case that you turned down.
That was the oil case that I turned down. And that involved several states, but a smaller number of states, a large and a large participation by some private counsel as well. But the insurance case was all people working with the various AG offices. Many of us didn't have computers right at the beginning, but we were getting them, and we began switching from a whole lot of faxing of things back and forth to one another to email rather quickly, to the great relief of the people manning the fax machines, who were finding that that this case had needs that just about equaled the needs of everybody else in the office.
How did you get the case organized with that many states, and this being a pretty novel venture for the states?
It was. There were a number of leaders of the case. I wasn't so much the leader, but I became, in many respects, the parliamentarian. Mm-hmm. And I certainly had a feel for a group, and there was an executive committee created. I became kind of the secretary to the executive committee, and developed agendas, minutes, and regular updates for the states. There was a weekly update because we were in active litigation. Mm-hmm. Committees were created to work on a variety of the legal issues. Judge Schwarzer was the judge, the trial court judge, and he put us on a track of a whole series of dispositive motions early on. So the case, and then decided them in ways that took us through the appellate court before there was any discovery in the case.
Was the federal government involved in the case?
The federal government was not. A lot of this was before my time, but I was told that the case was shopped to the federal government, mm-hmm. and they declined.
Oh, that's interesting. And as we said before, it went all the way up to the Supreme Court. And what happened in the Supreme Court?
In the Supreme Court, there were two issues that made it to the Supreme Court, and two decisions. One of them, the one that's generally referred to, was the one involving the Foreign Trade Antitrust Improvements Act, the FTAIA, which is still, or I should say again, quite a significant issue. And the Hartford case turned out to be the first one in which the Supreme Court really addressed the question of what happens when there is an alleged antitrust violation by foreign players operating in foreign countries. But they do have in mind that there will be an impact, and they intend that there will be a significant impact on an American market. That was the case there, and of course they found that the Antitrust Improvements Act did embrace such a situation.
So that was a very important precedent, and it's actually become useful for the federal government, even though the federal government had declined to get into the case originally. So
that's right, yeah.
Cheers for the states.
Well, we like to think so, that's right.
What happened after the Supreme Court? Did the case get settled?
The case came back to the trial court. It was a different judge at that point, mm-hmm. and that judge pressed for settlement. And by that time, there had been a lot of water under the dam, or over the dam, and it was settled. It was one of the most novel settlements. I like to think of it actually as the first Cypre settlement in a case of this kind, although it wasn't denominated as such. And I became deeply involved in making it happen. Funds adding up to $20-some-odd million were given to the states to create an organization that would supply the kind of infrastructure. What had happened was that the municipalities who had been affected had by and large gone and developed through a kind of a series of self-help measures a number of risk pools, joint powers authorities, and so on, to insure themselves. But what they lacked was an infrastructure involving broad databases of material, best practices, and various other methods of communicating and developing what you need for good, essentially, underwriting and reserving practices. And so the money was given to us to set up an organization that would do that. And I became the person that worked with the National League of Cities, comparable county organization, and so on, to set up an organization that became a nonprofit and get the various officers appointed and bankroll it to get going and develop its projects.
That's very innovative. Did you learn things in that case that you were able to use more recently, for example?
Well,
talk about that a little bit.
It was particularly interesting to do something like that, although it was far more active than much of anything else we've done. But it was, as I said, a very good example of a cypre or cypre-like remedy that significantly benefited those that had been harmed to begin with. And later on, I became much more involved in cypre remedies.
Okay. I know you had a recent case involving Safeway. Were you able to use some of what you learned in the Hartford case?
Actually,
more recent Safeway case?
What I most learned in Hartford that became useful in Safeway was involved the issue of exemption. In Hartford, we had to brief, and I was on the committees that briefed the McCarran-Ferguson exemption, state action immunity, and I did a lot of research, what existed at that time, and developed what I think of as a kind of a feel for how exemptions in general work. When much later the strike occurred that ultimately led to our Safeway case, the major issue in that case, the major defense to the revenue sharing agreement that the supermarkets had entered into was that the implied labor exemption would cause us to be dismissed from court. And as I began to look at the agreement itself and think about the case and whether we should file the case, it became abundantly clear that that exemption was going to be a major issue and that it was going to be a huge issue for the case, and it was therefore a really important case to file.
I want to turn from Hartford to another major antitrust case of our era that I know you worked on because I worked on it as well, and that's Microsoft. I know you had your involvement increased towards the end of that case. And originally there were 20 states, and there was a trial, and we tried it with the Department of Justice. And then the Department of Justice settled the case, and half the states decided to settle, and the other half, led by California, continued to litigate. I don't know how much you know about the decision that led California and Iowa and others to continue to seek greater remedies. Were you involved in that part of the case at all?
I was somewhat involved in it. Of course, you yourself had represented the states collectively during the liability phase of the trial, and states like California had played a less dominant role. But when the time came to settle it, after it had also gone through its whole appellate process, and the court was pushing very hard, the new judge was pushing very hard for settlement, it became very much an AG level issue. And there were numerous conversations among the attorneys general who were involved in that case, to which I was not privy, but there were those that were really important. After the U.S. DOJ had come up with a settlement and was looking to the states to join the settlement, and there was discussion, there was a period of several days in which the states were talking at the staff level and at the AG level about the remedies, and there was great dissatisfaction with the limited remedies that had been adopted in the U.S. DOJ settlement, and there was a lot of discussion of the kinds of remedies that would be needed for us to feel that we could settle. There was also a great deal of concern about what it would take to go forward without DOJ in a case of this prominence, this significance, and in a market and in an industry that was changing so rapidly and that was so challenging. So ultimately, it was an AG decision, a great flurry of negotiation, seeing what would work. 9 states ultimately decided that with the additions that had been that they had been successful in getting agreement on, that they would be willing to settle. California was not, and my then Attorney General, Bill Lockyer, was very personally involved in persuading other states to stay with California and to continue to challenge and pursue a more robust.
Yeah, I know you were heavily involved in the enforcement stage of the case, which itself was very interesting because it involved a complex final judgment and consent decree, and as it turned out, on 8 years, which could put a serious strain on state resources to enforce a complicated decree like that in a high-tech industry. Can you talk a little bit about how California was able to fulfill its duty to enforce the decree over that period of time?
Well, we needed a lot of help, of course. There had been a settlement of the potential appeal from the court's judgment finally after our remedies trial was done, and that included enough money to fund a certain amount of staff, as well as outside counsel and outside economic advice, as well as technical advice over the period of it. And so the states collectively engaged yourself as outside legal counsel and an extremely skilled and talented technical man, Craig Hunt, as technical advisor. He began to work with the technical committee that had been part of the DOJ settlement, not easily at first because the two groups were still quite separate, but over a period of years began to work very closely together. I was myself very much involved for the first couple of years of the enforcement process. Ultimately, someone else in my unit, one of my deputies with a tech background, Adam Miller, became very involved, and he followed it all the way to the end, as did Lane Lindeback in Iowa and several other individuals from some of the other states involved.
Before I leave Microsoft, I want to get your opinion. Do you think the states made a positive contribution to that case?
I think we made a very significant contribution to the case in probably most importantly, during the latter portion of it, it was clear that a lot of what had been anticipated to happen with regard to opening up the market by making protocols available and allowing greater interoperability wasn't really happening. And the states were determined to make that point and to press for a continuation and extension of the decree for a period of time. US DOJ did not join us in that. Some of the states in the so-called New York group, including New York itself, did join us in that, and we were successful. So that, and during that last 2-year period, I think a lot more was done to make the remedies really fruitful. Although I think no one felt that there will always be complaints that it wasn't what it should have been. But by the same token, I think it was important to show that we were determined to make it work, and the court was also, and she was, I think, very committed to that.
We've talked about two cases, Hartford and Microsoft, where the states and the federal enforcement agencies didn't necessarily see eye to eye entirely. Is that the usual way things work?
It's incredibly rare. The number of times that has happened, at least during my career, in my experience, I can count on the fingers of one hand.
How does it impact your decision to bring a case if you know the federal agencies are involved in the case already?
Well, they have enormous resources and they have an enormous area of responsibility all over the country. We like to use our resources the best possible way, and with those allies that are really, to whom we can really bring something to the table. So when we embark on an investigation, one of the first questions, of course, is what's California's stake in it? And we look at that very closely. We want to see whether are there local markets, are there California players, is this something that really has a major California aspect to it? And then the second question is there a particular value added to our participation? And one of the earliest examples of that in my experience was a case that I worked on personally before I became the head of our antitrust section. The first merger case I worked on was the Wells Fargo First Interstate Bank merger, which was quite California specific, so that question was answered. And it materialized very quickly that all of the greatest concentration and potential problem was in the Central Valley of California. So we began looking at and hired an economist to look at whether or not agriculture would be affected, ag lending, and the relationship between ag lending and commercial banks. And we found that there was significant impact there, and we began focusing on that. It was very much appreciated by Tony Nanny and the banking group at US DOJ. It was not an area that they traditionally looked at, but it was something that really factored into some of the decisions about the divestiture package.
Some people criticize dual state federal enforcement as being inefficient in our federal system. Do you think dual enforcement's a good thing or a bad thing?
Well, I think it's a good thing. Not that we always enforce on a dual basis. Harking back to my municipal government experience, the term redundancy is not always a bad thing. If you talk to an engineer, for example, redundancy is something that is designed right into systems that are really meant to work and be reliable. Whether it's a water system or an electrical generating system or something like that. And I think of antitrust as and antitrust enforcement as one of those kind of fundamental things where redundancy is important in exactly those ways.
I'd like to ask you a little technical question. When you want to bring a case in California, can you describe the process you have to go through to get permission to bring a case?
We have to go through a series of different steps, working our way up a chain. I think every organization has its bureaucracy, and there are, of course, different responsibilities at each level of our bureaucracy. We get involved. We tend to have a preliminary look at the situation. That determines whether or not we become involved. We open up a full-blown investigation. And even that decision to open a full-blown investigation, if it's going to involve making use of our administrative subpoena powers, involves preparing a package, as we call it, an AG package. And the AG has to sign off on delegating, it's called a delegation of authority of those powers to the deputies, to the section and the deputies in the section to exercise those powers. We like to stay in investigative mode, which is confidential, which certainly benefits the industry being investigated, as long as we can. But then if the decision is going to be made to file a piece of litigation, that also goes up the very same chain, all the way up through our division chief and our chief deputy and then our attorney general. And I think most other states have may not have quite as many layers as we do in California, but they go through a similar process.
I know the California Attorney General can enforce the Sherman Act. He or she can also enforce the Cartwright Act, which is the State Antitrust Act, which is a very powerful act that differs, I know, in at least a couple significant respects from the Sherman Act. Can you talk about how the Cartwright Act differs from the Sherman Act?
The Cartwright Act is much more specific than the Sherman Act. The Sherman Act is just a short little paragraph long, and the Cartwright Act goes on for pages. It specifies quite a number of violations, which the Sherman Act has relied on the courts to elucidate. So this puts us in a somewhat different situation. And the Attorney General obviously has a particular charge from the state constitution and authorizing statutes to enforce the Cartwright Act. One area of particular difference involves resale price maintenance, resale price fixing, which is stated in black and white in the Cartwright Act to be against the law. So we have departed from the Sherman Act at least in my office's interpretation of the per se nature of resale price fixing, because it is in black and white in the Cartwright Act. We also, of course, were one of the first states to adopt an indirect purchaser statute after Illinois BRIC, and that too is in black and white, and it's very clear and certainly has been broadly interpreted by our California Supreme Court. We have been attempting to bring indirect purchaser cases recently in the California Supreme Court, particularly since CAFA, because we think it's important to have more California Supreme Court and appellate court interpretation of the indirect purchaser statute, and ultimately we hope to do the same with resale price fixing.
Do you think it's a good thing that you have the power to bring these RPM cases, as you do?
Yes, I do. I think it's quite important. The states, of course, have been the laboratory for a lot of this. The states enacted in the 1970s Fair Trade Acts and experimented with that. It was discovered, of course, that a lot of those that a lot of the practices that allowed resale price maintenance during that period led to higher prices, and there's a fair body of legislative intent that not happen. So we continue to think that the economics of competition among interest rate brands and within a particular industry are important to have.
With respect to the indirect purchaser cases, I know that a number of states cannot bring those kind of cases. Does that fact complicate your relationship when you're working with states in a multi-state antitrust case involving indirect damages?
It's something that we've been sorting out over quite a period of time. There was a period when a number of states that did not have those laws would join simply because there was, and we would be interested in having them join, because there was at least the enforcement piece, some kind of civil penalty aspect to a joint complaint or injunctive relief that we shared. It has become something that has been much more focused on now, the distinction from state to state, by the defense side and certainly by the courts. And now there is far more limited participation by states that lack those BRIC repealers, even in a situation where there may actually be a good case for civil penalties or for injunctive relief.
We've talked about multi-state cases. Why are cases brought as multi-state cases sometimes rather than as individual state cases?
Frequently those cases involve, there are particular types of cases that tend to be brought in that way, as you know. Some mergers, of course, are brought that way, but often because states in merger situations are looking at state-specific things, we work together on a few issues, but separately on our state-specific issues. But in something like the reverse payment pharmaceutical cases, very large numbers of states have joined together because every state is a major purchaser of pharmaceuticals, and we share both an enforcement interest in those issues as well as a proprietary interest, whether as direct or indirect purchasers.
Are there advantages and disadvantages to bringing multi-state cases? Can you talk a little bit about what the advantages and disadvantages are? And
there's certainly both. The advantages, I would say, are pretty obvious. It's the advantage of the power, if you will, of so many states converging on a particular issue and feeling serious enough about it to file suit. And then there's also the opportunity to work together. We in the early days in the Hartford case began to talk about essentially forming a national law firm by joining together as we did. In something like the Microsoft case, when there were depositions being taken around the country, although we had outside counsel in that case, if the deposition was being taken in Utah, the attorney from the Utah AG's office would go to it and would take that deposition. It was extremely useful and cost-effective. There is definitely a downside. The downside is the administrative apparatus that goes along, and there's a particular downside when we don't agree with one another. Mm-hmm. I think that's probably true of any group of litigators representing different interests. Right. Different states have different stakes in the outcome, different priorities within their offices, and sometimes even different views of the law.
So I know you've worked overtime for a number of attorneys general in California. Can you just run through the list?
Well, when I was hired, John Vandekamp was Attorney General. He was the one that had filed the insurance case. Very shortly, he was replaced by Dan Lundgren, who was a fairly conservative Republican. Who initially was not our sense that he was particularly interested in or committed to antitrust, but he became so, certainly, partly with hospital mergers. He was deeply concerned about hospital mergers and pushed for investigations of hospital mergers. His father was a physician, and in fact, I think was Nixon's personal physician down in Southern California. And Lundgren had a real feel for what might be lost with too many hospital mergers. Ultimately, it was under Lundgren that the Microsoft case was filed, and of course, it was under Lundgren that the banking merger I mentioned, which involved impact on agricultural interests, which were very close to him. And to his interests, was filed as well. Then came Bill Lockyer, who loved antitrust issues. In fact, he was fond of telling us that of all of the different areas that he suddenly found to be his bailiwick, antitrust was the most intellectually interesting and stimulating to him. There were quite a number of oil company mergers during that period. He was very interested in those, learned a lot about them. I will say that he and all of them have been quite respectful of staff, of the economic analysis and the legal analysis involved, and and even when they have been quite personally interested, and of course they are always approached by the parties for meetings of one sort or another. They have generally included us, passed everything on to us, and waited for our analysis before any decisions got made. Bill Lockyer was the one with the Safeway case. He was very interested in that, partly because of his interest in labor. He was accused of bringing the case for purely political reasons, and I must say that we tended to grind our teeth as staff members bringing that case, convinced as we were that it really presented some very important antitrust issues when the Attorney General himself was out on the picket line with his baby son during a very, very acrimonious strike. But the case itself continued for years after that strike had been concluded, and I think everyone ultimately came to understand that it was brought for reasons of antitrust enforcement, and certainly decided on that basis.
So you've had attorneys general that cover a wide spectrum, from conservative General Lundgren to liberal General Lockyer. Has their political philosophy impacted the kind of cases you decided to bring as chief of the bureau?
It has really not in significant ways. I think that from a standpoint of mergers, every attorney general has had equal, equivalent interest in how anti-competitive mergers could affect the economy. In terms of conduct-based cases, there have been mild differences. I would say a lot of the differences don't have so much to do with enforcement philosophy as different industries that are perceived as particularly important or key to the Attorney General's enforcement authority.
As a final topic, I want to go back to something we touched on briefly early on, which is cypre settlements, because I know you know a lot about this subject and very thoughtful about it. And could you talk a little bit about cypre and what your role has been in overseeing cypre distributions and settlements in California?
It's extremely interesting to me. I will say California has had an interest from very early on in cypre settlements. California was one of the first courts to recognize cypre or fluid recovery as as something that might even be at times preferable to, in a let's say, a class action case to individual small claims with expensive claims administration. And we've done quite a lot with that. My real involvement in cypre and in the approach that we've taken to cypre distributions really came with the vitamin settlement. California had a separate settlement of the indirect purchaser claims that was partly private indirect purchaser class action and partly AG parens patriae settlement, and there was $38 million to be distributed within California to benefit purchasers of vitamins over the years. And as had tended to happen in earlier settlements, we began thinking about ways to spend the money, and I found myself sitting in meetings with private counsel talking about, well, should we spend it on this or should we spend it on that? I had spent quite some time as a member of a board of trustees and board chair of a large community foundation that had done a lot of competitive grant making. And between the fact that I really understood that competitive grant making was something that took a degree of expertise that neither I nor the private counsel in the case really had, and the potential problems that could arise in essentially handing out money to the first organizations that came knocking on the door, or organizations that had particular connections either to the council or to the Attorney General or even to the court, began to push for engaging an administrator who would conduct a full-blown competitive grant-making process with a lot of outreach to organizations and a real attempt to get the nexus of benefit to the original, those who had originally been overcharged for their purchases of vitamins. It has worked out extremely well, and there have been some wonderful models of how that grant making has worked in California. We have, since that time, both with private counsel and more particularly with some of the parens patriae settlements that we've done on our own, pursued that particular approach, frequently with the same cypre administrator. The courts have certainly been happy about it. And in California now, cypre is recognized as something that not just as a remedy for a residue after a distribution, but at times the most appropriate remedy in a certain type of case.
That's great. I understand our time is coming to an end, and I just wanted once again to thank the ABA for this opportunity, and I want to thank you for participating. You've been a wonderful subject, and I just wish we had a little more time.
Me too. I've really enjoyed the talk, and it's a privilege to be part of the process.
Thank you.